On Radio 97, it's Wayne and Jess for breakfast on this Thursday morning. And Jess, you know what that music means, don't you?
Our Radio 97 lawyer is in. Despina Priala joins us from Priala Legal, which is a boutique law firm in Runaway Bay on the northern end of the Gold Coast. And as principal of the firm, Despina brings a wealth of knowledge, having practiced property and commercial law for over 25 years, to provide an exceptionally high level of legal expertise to her clients. And we're very lucky to say she's here every Thursday to offer some general advice, because of course each case varies from person to person.
Yep.
But to speak on the latest hot topics, we welcome her now. Good morning, Despina.
Good morning, Jess. Good morning, Wayne.
Well, here we go again, another week, and this time we're talking about something I think that at one time or another everyone will have to come to terms with and will have to know a little about, and that is powers of attorney. This is a big issue, isn't it? So where do we start?
Well, we start with asking, do you have an enduring power of attorney, Wayne or Jess? No? Well,
but we should apparently. Is that right?
You absolutely should. Everybody should. Once they reach 18, so adult age, you should have an enduring power of attorney in place. So we can talk about what that means and what the word enduring means as opposed to a general power of attorney. So that's really important to understand. So at a basic level, the enduring power of attorney means it will endure beyond incapacitation. So if you become incapacitated at some stage in your life, whether it's temporary or permanent, then if you have an enduring power of attorney in place, a valid one, that you've signed and have it properly witnessed and your attorneys have accepted their role under that document, then those attorneys, or if it's just one attorney, can then take on that role and manage your affairs for you.
I guess we always want to try and avoid the fact that maybe one day something could happen to us.
Yep.
So maybe that's why we don't broach this topic more, but we should.
It's a topic that a lot of people don't like to talk about, and you really do need to become comfortable in talking about your estate plan, because everybody has to have an estate plan, and part of that estate plan is having a valid will and also having an enduring power of attorney. So the enduring power of attorney is a document that you can put in place while you have capacity, so while you're of sound mind, obviously, and it can sit there if it ever needs to be used in the future while you're alive, but for whatever reason you're not able to manage your own affairs.
Now it can extend beyond family. Who do we go to?
So this is probably one of the most important decisions someone will make, because you're giving them a role of trust. So it's got to be someone that you really trust 100% to carry out this role for you, because it's a very powerful role. So they can manage your financial affairs and they can manage your personal affairs if you choose to allow them to do that in this document. And you can, for example, put conditions on their appointment and specify certain limitations or not. But essentially, the appointment itself is quite a powerful one.
Okay, so anyone can take on this role. So it could be family, it could be a trusted friend, it could be your neighbour, partner.
So typically we see husbands and wives, for example, they will appoint each other, not always, so it depends on your circumstances. But you can have your spouse, you can have your adult children, you could have extended family members, you could have a professional person. So there's no, I suppose, limit as to who you can choose. It's about trusting someone and having that person, knowing that person will do the best that they believe to look after you.
Actually, just on that subject, with partners, now, if your partner has the power of attorney and you are both, for example, you are travelling together and something happens, what would happen in that case? Because obviously, you're more likely, if it's someone who's totally separate from you, be it a lawyer or a friend, etc., rather than someone you're living with, you've got more chance of perhaps exiting the world. Perhaps I may not want to talk about this, but at the same time as your partner, rather than your lawyer, for example.
Yes, that's right, but that doesn't mean you should appoint your lawyer.
Yeah.
When we see clients and we talk about enduring power of attorney, and someone says, "I want to appoint my husband," we don't just leave it at that, because I explain to them, well, what if something happens to your husband, and at the time that you need someone to look after your affairs, your husband actually has died, or he himself is incapacitated. Therefore, you don't actually have an attorney. So we always suggest to the clients, well, have a second substitute attorney or a third substitute attorney, and even a fourth if you wanted to cover the circumstance if a particular attorney cannot act. So they can't act in certain circumstances. For example, if they've already passed away, if they're incapacitated, what if they've travelled abroad, they're uncontactable? And the other circumstance which people don't often think about is, well, what if they actually don't want to carry out the role at all?
Yep.
You know, so no, sorry, it's not for me. I don't really want this responsibility because it is a big responsibility. So you've got to think of substitutes. Okay. Now, the other thing is that you can appoint more than one person as an attorney. So you can have two or more together as attorneys acting at the same time. Okay, that makes sense. So when you have that, you've got to decide how they are to carry out their role, which is very, very important. So if you have two people as your attorney or attorneys, then you need to decide if they're going to act jointly or jointly and severally. And there's a very big, big distinction between that, and it's very critical that listeners and clients, they understand what the difference is. So if I make a power of attorney, enduring power of attorney, and I appoint two people, if I appoint them jointly, they have to act together. One cannot go off rogue and do whatever they like without consulting the other attorney.
It's a joint decision.
Yeah.
It's a joint decision, but if they're appointed severally, then that's exactly what they can do. One can actually act without the other attorney's consent. Okay? So there is a big distinction there between the different types of appointments.
And is one way of doing it better than the other?
It depends. Depends on you, your family, and who you're appointing. So if you appointed two children, for example, as your attorneys, and you appointed them jointly, what if those two children absolutely don't get along and they don't even talk to each other?
Yep.
I say to clients, what's the point, in some ways, to have two people coming together to manage your affairs? They will immediately start arguing and there'll be disputes, and then you actually miss out because they're there to look after you and do things in your best interest. So that creates a problem.
Yeah, I was just thinking they may not always have your best interests at heart, maybe their own if they're squabbling over it.
That's right. And then you've got the other circumstance where I have clients who, I have no one particular who has 3 adult daughters, and I said, okay, well, she says this particular daughter is very responsible financially, she'll be the best person, but I can't put her in because the other 2 daughters will get very upset. And we're all a happy family, we all get along, but if I don't put all 3 in, then they'll all get upset as to why they missed out.
Marsha.
That's it.
It's like the Brady Bunch, isn't it, sometimes? What about a civil union of the same sex, though?
Yes.
Is it the same thing that occurs?
Yeah, well, when you are a person, you make your enduring power of attorney, you can, as I said, you can choose whoever you like. So if you are in a same-sex relationship, a civil partnership, you can choose that person if you wish.
And then what if...
Is there a best number? Sorry, is there a best number to to have? I mean, you suggested at least 2. Is 3 good? Is 4 good? Is 5? I mean, how many is too many?
Well, you can only have up to 4.
Okay.
I believe in Queensland that's the current rules, and maybe similar in New South Wales. But it does depend on your situation. It really does. You can have just the one person, as I said, and have your substituted attorneys. So there's always a backup, and there's always someone there to be able to manage your affairs. So that's the most important bit.
Now, with the same sex, though, if you break up from that civil partnership, what happens if you've appointed your partner and you go your separate ways? What happens then?
Well, if you are in a marriage or a same-sex relationship and you divorce, and that particular spouse, your spouse, was the attorney, the sole attorney, then that document becomes void. So it actually invalidates it. So we call it, it's revoked. Okay, so that means that you actually don't have a valid enduring power of attorney in place, and you need to. So this is quite important too, because in Queensland we have some new changes coming up. So as of the 30th of November, we have brand new forms for making enduring power of attorney, general powers of attorney, and advanced health directives. So those forms are coming in place effective from the 30th of November, and it's a good opportunity for people who may have their powers of attorney in place already to go see their lawyer and review what they have in place and make sure it's actually current and up to date. And if they want to actually change it, you can do it before the 30th. But if you want to wait till afterwards, you can, of course, but it's under the new forms. So you must use those new forms from the 30th of November. That's very important. But I think it's opportune with these changes in Queensland for people to actually review what they've got in place, because an estate plan is not set in stone. It's supposed to be regularly reviewed. So if you have a change in circumstances, for example, you're getting married, you're getting divorced, okay? What if your attorney goes bankrupt? What if the attorney dies? What if there's additions to your family? What if you want other people to manage your affairs? What if someone does something wrong to you in the family that you had them appointed as your attorney and you no longer want them involved? So it's as we evolve through life and we have personal circumstances that we face every day and changes, then so too should your estate plan be reviewed to make sure it reflects your current state of wishes, what you would like for your estate plan.
And a lot of it applies to New South Wales as well. I guess those changes, though, aren't effective like they are in Queensland in November.
That's right, no changes in New South Wales, but in New South Wales it's the same. You make an enduring power of attorney or you can make a general power of attorney, and the same principles pretty much apply across the board. So it's about getting the right advice about what an enduring power of attorney is, what it means to you, for you as a person and your family and your assets and what you have, okay? And then understanding you can appoint several attorneys, but how do you do that? How do you appoint them? What type of appointment is it and the role they take on? And to understand it's got to be someone you trust. Because I've had clients come to me and say, look, the person I trust is my son, but he's in the UK. And I don't really trust anyone else, but I'll put someone on that's local. Well, it's not actually the right thing to do just because they're here living with you, say, on the Gold Coast. No, because if they're the wrong person, you don't want them having this position of power. Yeah?
Mistrust.
That's exactly right. So, and the son from the UK will just have to figure out a way to come back and manage your affairs if that's the case. So, if you don't put an enduring power of attorney in place, right, and something happens to you, it can be very, very difficult, right, because you don't have someone that can go in and manage your debts that are piling up. So if you're in hospital, for example, and you're there for weeks on end, who's going to manage the medical bills? Who's going to pay for them? Who's going to manage other debts? Who's going to manage your assets, your personal assets? So if you don't have an attorney, then the whole thing could be in disarray by the time you come out. And if you never come out and regain your capacity state, if I could call it that, then someone has to manage your affairs until the time that you pass away.
And just one last question before we have to wrap up this first segment. Just on this issue, you said before that we should all have a power of attorney. What age? I mean, were we talking from 18 years of age onwards?
From 18 years of age onwards. So,
Is it illegal?
yes, a lot of young people say, well, I don't really need it. I said, well, because they don't have any assets. I understand that, but it also caters for an attorney to make some personal and general health decisions under that document if you so wish. And I think that's very important for anyone over the age of 18 that has capacity to have this in place for them.
Either side of the border can come and visit you and you can help them out, couldn't you?
Absolutely, whether it's a New South Wales power of attorney or a Queensland power of attorney, and we can talk about which one may apply if they've got assets in different states. So that's always a tricky area as well, but yes, I can certainly help them.
This is Talking Law on Radio 97. We'll take a break. We're speaking with Despina Priala. And if you have a question to do with law, any sort of question at all, Despina happy to answer the question for you. We'll present it on your behalf. Just send us a few details to breakfast@radio97.com.au. And after the break, there are some changes to Australian consumer law coming up. We'll find out what that means to you in just a second.